Kia ora for those still joining. We're just waiting for the numbers to trickle in, still counting up. I think we might be about there. So I will kick us off. Tēnā koutou katoa i ngā tangata I tai mai nei ki tēnei kōrero. My name is Jessie Porter. I've been a privacy advisor at Oranga Tamariki for about 5.5 years now, which is, it's fair to say, a unique and challenging environment in which to do privacy well. Agencies working in this child welfare and protection space share high volumes of identifiable information about individuals, particularly about children and young people. And a lot of that personal information that needs to be shared is sensitive, often highly sensitive. The Privacy Act supports this by providing ample grounds to share even very sensitive personal information when necessary or appropriate. And so my mouthful of a topic today is privacy considerations when using the information sharing provisions of Section 66C of the Oranga Tamariki Act. I do a wee bit of talking up front here, but the slides will start to move shortly. And I picked this topic because of how often I've heard people say that the Privacy Act just doesn't apply when you're sharing information under 66C. But as I'm about to go through, wherever we have an obligation to share personal information to support the safety and well-being of children and young people, we also have an obligation to share that information safely, because we cannot keep children or others safe if we do not also protect information that could put them in harm's way. The inappropriate release of a confidential refuge or caregiver address to a violent partner or parent is a more obvious example, but there is unfortunately just no shortage of very real harms that can be caused by the careless handling of personal information in an environment like this. For the second half of my session, I've put together a very simplified version of one of the information sharing training sessions that we run for our frontline colleagues here. And although we won't be able to get down into the operational weeds like we do in the training itself, I've condensed down the key messaging and advice that we provide into what I hope will be useful general guidance on what practitioners should be thinking about when they're using Section 66C of the Oranga Tamariki Act to share information. Or perhaps you're looking at designing similar training for your own agency. And hey, if you like the way we try and break down and contextualise privacy considerations at that operational level, you are certainly welcome to steal our ideas, because we want to see people using 66C confidently. And using 66C confidently includes those considerations of any privacy implications. Because it's not about privacy for the sake of privacy or even privacy just for the sake of compliance. It's really important to recognise that in contexts like child harm and family violence, good privacy practices help to keep people safe. Now, I think I'm billed for about an hour today, although just a heads up, my presentation runs for about 30 minutes, give or take. So you will get a bit of your afternoon back. If you do have any questions, please just pop them into the Q&A window of the webinar, as I'm not able to see raised hands. I won't be watching the Q&A while I'm running the presentation, but I do have a couple of colleagues in there who will answer where they can. And I'll check back at the end as well for any general questions I might be able to answer. Although please do keep in mind I can only speak at a very high level. I can't provide operational advice or advice around specific situations. And as well, although I don't expect there is anything controversial in this presentation, all views and opinions expressed are purely my own and don't necessarily reflect the views and opinions of Oranga Tamariki. So to start us off, what is Section 66C of the Oranga Tamariki Act? 66C allows child welfare and protection agencies and independent persons working in the child welfare and protection sector to use and disclose personal information about children and young people for explicitly defined purposes. And for the rest of this presentation, whenever I refer to child welfare and protection agencies, that's inclusive of independent persons. Just as an example, a child lawyer or a child psychologist working as an independent trader. We will see the full legislative wording later in this presentation, but just for now, those purposes for use and disclosure under 66C boil down to preventing harm or neglect to a child or young person, family group conferences and other care and protection work, making, carrying out or reviewing a risk assessment, needs assessment, prevention plan or support plan for a child or young person, and external services facilitated by Oranga Tamariki for a child or young person and their family or whānau. And an earlier section of the same part of the Oranga Tamariki Act protects people from civil, criminal, and disciplinary proceedings in respect to disclosure of information concerning a child or young person under 66C, unless they disclose that information in bad faith. And that does include when the information disclosed also concerned any other persons aside from the child or young person. And I'll be coming back to that bad faith point later. Before that, though, let's also touch on what the Privacy Act is and what it requires. In brief, the Privacy Act governs how we can collect, use, and disclose personal information, including what safeguards must be in place and what rights people have in regard to their personal information. The core of the Privacy Act is the 13 Information Privacy Principles, otherwise known as IPPs. These 13 IPPs will be familiar to many of you, so I'll just run through a very whirlwind tour, just for the folks who may not be as familiar with them. So IPP 1 requires that collection of personal information be necessary for a lawful purpose connected with the functions or activities of the agency. In my context, that's primarily functions and activities relating to child welfare and wellbeing. IPP 2 requires personal information to be collected from the person it is about wherever possible, while IPP 3 requires that people be notified about that collection wherever possible. IPP 4 states that the manner of collection must not be unfair or unreasonably obtrusive, particularly when collecting personal information from children or young people. IPP 5 requires agencies to take reasonable steps to keep personal information secure. IPP 6 gives people the right to request access to personal information held about them by an agency, while IPP 7 gives people the right to request that an agency correct personal information it holds about them. IPP 8 requires that agencies take reasonable steps to confirm the accuracy of personal information before using or disclosing it. IPP 9 states that agencies may only retain personal information for as long as they have a lawful purpose for doing so. In the context of government agencies, that includes to meet retention requirements under the Public Records Act. IPP 10 says that agencies can only use personal information for the purpose for which it was collected, unless a specific exception applies. And IPP 11 similarly prevents agencies from disclosing personal information to additional parties unless a specific exception applies. IPP 12 places additional restrictions on personal information being shared with parties outside of Aotearoa, New Zealand. And lastly, IPP 13 sets various restrictions with respect to the assigning and use of unique identifiers. For example, NHI numbers assigned by the Ministry of Health, IR numbers assigned by Inland Revenue, or CIRUS numbers assigned by Oranga Tamariki. And you might be thinking that some of these actually sound pretty good, especially when you're talking about using and sharing identifiable information about vulnerable tamariki and whānau. You'd want their information to be handled securely. You'd hope it would be accurate, that it wouldn't be bandied about unnecessarily, and certainly that we wouldn't be needlessly traumatising children to obtain it. And if you are thinking along those lines, I like you already, and as it happens, we're not alone in that thinking. Just a note here for the next few slides, I show the sections of legislation that I'm speaking to, but I don't need or expect you to read them in full, and I'll be covering the relevant aspects as I go through. So how does the Privacy Act apply to Section 66C of the Oranga Tamariki Act? Let's look first at Section 66Q of the same Act, which specifically addresses the relationship between 66C and the Privacy Act. Clauses 2 and 3 confirm that 11 of the Privacy Act IPPs still apply when collecting, storing, using, or disclosing information under Section 66C or other relevant sections of the Oranga Tamariki Act as noted here. The only IPPs that don't explicitly apply when sharing information under 66C are IPPs 2 and 3. IPP 2, as we just saw, requires that information be collected directly from the individual concerned wherever practicable. That isn't possible or relevant here, since 66C can only be used by child welfare and protection agencies to share information among themselves. IPP3 is likewise irrelevant because it applies when agencies are collecting information directly from an individual. I understand that the upcoming IPP3A notification requirements that will apply when collecting information indirectly will also not apply when information is being shared under 66C. The Oranga Tamariki Act contains its own consultation requirements that I'll speak to in the next slide. Clause 4 here does note that the Oranga Tamariki Act overrides the Privacy Act if there are any other inconsistencies. And I suspect this is what got generalised originally as the Oranga Tamariki Act overriding the Privacy Act more broadly, which then got misinterpreted as the Privacy Act not applying at all. As we see here, though, that is simply not the case. Although the notification requirements of the Privacy Act don't apply, there is a requirement under Section 66K of the Oranga Tamariki Act to, wherever practical and appropriate, actively consult with a child or young person or their representative before their personal information is shared, to provide support as needed for them to understand the situation and express their views, and to take those views into account. Note that this requirement isn't a requirement for consent, just consideration of their views. Along with that consultation requirement, the explicit purposes for use and disclosure under 66C are very context specific and so ultimately narrower than those laid out under IPPs 10 and 11 of the Privacy Act, and they can only be used by child welfare and protection agencies as defined under the Oranga Tamariki Act. So it's only those notification requirements under IPPs 2 and 3 regarding collection that don't apply when agencies are sharing personal information under 66C. The rest of the Privacy Act still applies. And I've already said this, although I don't think it can be overstated. The reason the Privacy Act still largely applies when sharing information under 66C is because privacy, is a fundamental aspect of keeping people safe. We cannot keep children and young people safe or other people in their lives if we are not also protecting that information that could put them in harm's way. In addition to the provisions of the Privacy Act that still apply when we're sharing personal information under 66C, there are some other things to watch out for. For example, although there is a partial list of child welfare and protection agencies within the Oranga Tamariki Act, to get a complete list or understanding of agencies that meet this definition, you would need to look at 4 different pieces of legislation as seen here: the Oranga Tamariki Act, the Children's Act, the Education and Training Act, and the Community Housing Management Act, and the record of any agencies given special designation by the Governor-General, wherever that is. Most agencies working in the child welfare and protection sector are likely to qualify, but there are a number of agencies working more peripherally within the sector who don't meet that definition. Parents and guardians also do not fall under the definition, including the definition of an independent person, so 66C cannot be used to disclose information to them. However, personal information about children and young people can be shared with parents and guardians under a number of exceptions within the Privacy Act. For example, to meet child welfare obligations under the Oranga Tamariki Act. So before sharing information under 66C, it is important to be confident that both you and the recipient are in fact child welfare and protection agencies, at least for the purposes of 66C. And as mentioned earlier, 66C does have specific and explicit definitions of the purposes for which it authorises the use and disclosure of personal information relating to children and young people. Not everything that might help a child or young person will necessarily fall under these definitions. So sharing in good faith means being mindful that your purpose for sharing does in fact fall under one of the purposes as defined in the Oranga Tamariki Act. Now, I've also spoken about good faith and bad faith, and this is another one to watch out for. So just as a reminder, that's in reference to a section of the Oranga Tamariki Act that protects individuals who share personal information under 66C from civil, criminal, and disciplinary proceedings unless they disclosed the information in bad faith. However, there is no definition of bad faith in the legislation or guidance on how it should or would be assessed in terms of civil, criminal, or particularly for agencies, disciplinary proceedings. So what if you had good intentions, but the recipient wasn't actually a child welfare and protection agency? Or what if you had good intentions, but were so rushed you forgot to password protect a spreadsheet containing sensitive personal information before you emailed it? To my knowledge, this hasn't been tested in court, and the honest truth is I have no real idea what would or wouldn't be considered bad faith. But I would expect that bar to be reasonably high. We're talking active malice or gross negligence as opposed to merely human error. So next up, I have got a few slides from one of the training sessions that we provide to our frontline colleagues, which speak to responsible information sharing. Although the primary focus is on 66C, we also cover the other information sharing enablers within the child welfare and protection sector, particularly the Privacy and Family Violence Acts. Ultimately, though, the well-being and best interest of the child or young person are the first and paramount consideration. Privacy is important because it is fundamentally about the safety, well-being, and best interests of the people whose information is being collected, used, and disclosed. As I say, it's not just a compliance obligation that's separate to our focus on keeping children safe and well. We simply cannot protect tamariki if we are not also protecting the information that could put them in harm's way. So these are the questions we encourage our colleagues to ask themselves to have confidence that they're sharing personal information in good faith. How will sharing this information benefit the child or young person? Who can help if they're given this information? Are there any risks either to the person whose information is being shared or to any other people? What do people need to know to help? What don't they need to know? Is the information accurate and up to date? How can the information be shared safely? And what should we tell the people whose information we are sharing? In the training itself, these questions each have their own slides that go into a bit more detail. We won't be going through them all today, but I will take you through a couple of what I feel are probably the most important questions to ask. Number one, whether there are any safety risks, either to the person whose information is being shared or to any other people, is one of the most important questions to ask before sharing information. At the severe end of the scale, there's a risk of physical harm to someone. That could be from someone who already means them harm, learning where to find them, or someone who already knows where to find them, learning that, for example, this person has raised allegations against them, or is themselves being investigated regarding unsubstantiated allegations of abuse. There's also a risk of interfering in active investigations into child welfare concerns. So the sorts of questions we can ask ourselves here: could someone's physical safety be at risk if their home address, workplace, or school was known? Could sharing this information lead to someone being harassed, losing their job, or being alienated from family, friends, and community? Could sharing this information cause someone embarrassment, anxiety, fear, sleeplessness, or uncertainty? And could sharing this information interfere into an active investigation or have a chilling effect on people reporting concerns? And given the sector's need to often consider and prioritise the more severe risks, we know it can be hard at times to focus as much on some of the less severe risks like anxiety or embarrassment. That said, though, even seemingly minor harms can have a really disproportionate impact, especially on vulnerable children and young people. In terms of what people don't need to know, we challenge the idea that it is always best to provide as much information as possible. Particularly in the context of child safety, not being discerning about the information that's being shared can actually have the opposite effect. Sharing certain information may put children, young people, or others, such as notifiers, at risk of harm. Sharing certain information may make children and young people feel uncomfortable or even unsafe. And often it's actually simply not helpful. If someone's needing to make a decision about a child or young person, particularly if they're needing to make an urgent decision, having to sift through additional information that's not directly on point can confuse the issue and actually delay an appropriate response. We also strongly encourage people to get into the habit of documenting any information sharing they do, in particular what information they're sharing, who they're sharing it with, why they're sharing it, and if they're not consulting with the person whose information is being shared, why they're not consulting. We encourage them to include any additional information they can record, such as those questions that we just looked at, but in particular to make sure they are always recording these basics: what, who, why. We also try to break down information sharing and privacy as pragmatically as possible. So an easy one to start with: is there an immediate and serious risk to the safety of a child or to anyone else, including family, whānau, caregivers, notifiers, or ourselves and our colleagues? If so, you can share the information under the Privacy Act. And as mentioned at the beginning, although I'm talking about Section 66C today primarily, I felt this was an important slide to keep in. If there is an immediate and serious risk to anyone, you can share that information under the Privacy Act. Share the information that will help with the people who can help. Often there's not necessarily a pressing risk to anyone, but sharing information may still be the right thing to do to support the safety and well-being of a child or young person. So these are the times that information relating to children or young people can be shared under Section 66C of the Oranga Tamariki Act. In the training proper, I've already spoken at this stage about the definition of a child welfare and protection agency and how the wording of 66C makes things much clearer in our context, but still isn't always as straightforward as intended. And so here I've done my best to summarise that legalese into plainer language. If you're sharing information with one or more of the agencies listed on the left, and you're doing so specifically for one or more of the purposes listed on the right, which is that same list we looked at in that earlier slide introducing 66C, then you're good to go. And as I went over earlier, those definitions on the left don't include parents and caregivers. However, it can apply to iwi and Māori providers and other NGO and community providers. If you need to share personal information, but perhaps not with one of the agencies we just looked at, or not for one of the purposes we just looked at, that's not necessarily a showstopper. You may still be able to share the information again directly under the Privacy Act if it is for one of the purposes on screen. To prevent a serious threat to a person, as we went over, or to public health and safety more broadly, for maintenance of the law, where it is legally required, or where you have consent. And when we talk to our colleagues, we try to debunk the common misconception that privacy just means you can't share information. Because although our privacy rights absolutely do include an expectation of confidentiality, when that is the right thing to do, there is equally an expectation that information about us will be shared when that is the right thing to do. The Privacy Act generally doesn't prevent information from being shared when doing so is in the best interest of a child or young person. The Privacy Act just asks that when their information is shared, it is shared as safely and respectfully as possible, which I'm sure is a sentiment we can all get behind. And our main training also includes a similar slide on sharing information under the Family Violence Act as well. However, if the information sharing isn't for the benefit of a child or young person or other purposes under the Oranga Tamariki Act or other relevant legislation, doesn't relate to anyone's safety, isn't legally or otherwise required, and we don't have consent, are we sure we actually do want to share that information? And sometimes there may be a good reason to say yes, and those are the sorts of unique situations where we encourage our colleagues to come to us for advice, and where I'd encourage you as well to reach out to our counterparts within your own agencies just for a bit of a steer on sharing that information appropriately. There is a flip side to this as well. Because if we know how sharing information will benefit a child or young person, and we know that we're sharing safely and respectfully, we can be confident sharing even very sensitive information. On the other hand, sharing information can also cause unintended harm and in ways we may not be able to predict, because we work in an environment where, unfortunately, both sharing information and not sharing information can potentially result in harm to a child, to a young person, or to others. Often there are very real risks to either decision, and we won't always know what those potential risks might be when we're making that decision to share. Which means if we aren't clear about how sharing information will benefit a child or young person, that's where we need to pause. Because we usually do not have to share information when we don't think it is in the best interest of the child or young person. And again, we tell our colleagues that if something just doesn't feel right, come to us for advice. Here's the bottom line we give our colleagues though. When faced with a difficult decision regarding sharing information, do what is in the best interest of that child or young person. Do ask those good faith questions before sharing information. Do clearly document when you're sharing information and why. Do seek advice, such as from your privacy or legal experts when you need to. Then do what is in the best interest of that child or young person. The truth is, our social workers and most people in the child welfare and protection sector, particularly the frontline folks that 66C was designed for, are already doing privacy in their day-to-day work. They're already thinking holistically about the safety and well-being of the children and young people and families and others that they're working with. So we say to our colleagues that when you think you need to share information about children and young people, share it safely and respectfully, document it, but share it. Equally though, when they don't see a good reason for sharing it, don't share it until they do, and come to us when they need to. It's a good rule of thumb regardless of what information is being shared or how much. And our training also looks at some of the situations that the frontline has come to my team for advice on in the past. They certainly don't need us to tell them that the challenges that they face are often complex, they don't always have the information they need at hand, or that they're often required to make difficult decisions quickly and while under considerable pressure. For example, a paternal grandmother with an interest in the well-being of her grandchild asked for a copy of a recent report of concern, which includes the mother's address. The father, who is supposedly out of the picture, has a history of violence against the mother and she has a protection order against him. A parent's lawyer requests details of allegations of abuse against the parent. However, the allegations contain details that could only have been provided by someone who had been in the home on a particular day. A young person requests a copy of their own file to try and better understand their history. Their file contains disturbing information that the young person may not be aware of, and they have a history of self-harm and or of suicide attempts. A child has been placed with new caregivers who have not been told about certain disturbing events in that young person's past. Sharing additional information to fill in the gaps could help the caregivers understand and better respond to the child's challenging behaviours. And none of these examples are necessarily straightforward or have a single right or wrong answer. But as we've just gone through today, applying the considerations and safeguards of the Privacy Act can reduce the risk of unintended harm, even in challenging and complex situations. And hopefully you all also have experts you can go to help you navigate these waters and make those hard calls in your contexts when you need to. Otherwise, that is it for my talk today. So thank you all for coming to hear me speak. And a particularly big thank you as well just to the people who gave me feedback and let me do some test runs of the presentation to tighten it up a bit. Oranga Tamariki has more guidance on the information sharing provisions of 66C on the Practice Centre, and that's a public-facing website with sector-specific practice advice hosted by the Ministry. And if you'll bear with me just a minute or two, I'll also see if there's any questions in the Q&A that I can answer in the time that we have left. What have we got here? Oh, so I'll read out the question. I probably can't go into a deep answer today, but I will just acknowledge the question. So, sharing information with Oranga Tamariki and police about a third party whose behaviour is of concern. For example, the mother of a child says the father has been abusive and the mother is now having a baby. How much information would Oranga Tamariki expect to receive about the father of the child? Would Oranga Tamariki seek that information, for example, mental health information? It's a good question. It's not one I can go into in detail today because it is such a practice-heavy question. What I can say is that those sorts of situations are often contextual. what is relevant in one situation may not be relevant in another context. So that kind of, it depends, how long is a piece of string answer often isn't, as great as just having a very clear cut thing. As general advice, what I would recommend is provide sort of the minimum information that you believe is relevant and useful, and basically get them to request more information above and beyond that if you need it. That would be my advice there. So we've got a couple of questions that have already been answered, so that is great. Cool. I'll give it a minute or two in case anyone else has any other questions, and then I will close us off. But thank you all again for coming along as well. I might just read the answered questions out loud for people's benefit. One was, I think, about the recording going up, which will be going up. One person has asked, what section of the Oranga Tamariki Act are whānau able to use when requesting information about their tamariki? My colleague answered that request would normally be made under IPP 6 of the Privacy Act. A wee clarification there, it does depend on the age of the tamariki, the tamaiti or rangatahi. As a loose rule of thumb, we tend to apply 14 as the age at which a young person can generally provide their own consent, with variations for, intellectual disabilities or, particularly mature capacity. If the parent was considered to be able to request information for the child, then it would be IPP 6. If they were requesting information about, say, an 18-year-old, someone who was generally expected to be able to provide their own consent, it would likely be treated as an Official Information Act request, but with heavy consideration given to the interest of the parent or guardian in having information about their tamaiti or rangatahi. And I believe we've got some new questions in, so I'll stop reading out the old ones. One slide. Okay, good question. One slide refers to registered practitioners providing health or disability support services. Does this include non-regulated professions, the ones that self-register, such as the New Zealand Association of Counsellors? Truthfully, I'm actually not too sure off the top of my head, but that is actually one I'm going to go look up after this, because it is a good question and we probably do work with a few of those. Take me with a huge pinch of salt. My guess would be that if you've got ones that are sort of self-registering, self-regulating, and that are sort of formally recognised by their industries, I suspect they might fall under that definition, but I would strongly recommend just having a quick look at the Act yourself and just sort of checking that assumption there. More detail on how the Oranga Tamariki Act does not supersede the Privacy Act. Sure, I mean, in short, the Oranga Tamariki Act itself explicitly states that the Privacy Act still applies, with the exception of the notification requirements of IPP 2, IPP 3. But it actually is written in the Oranga Tamariki Act itself in detail. All of the other IPPs do still apply to 66C. Let's have a look. Random and irrelevant question. What little critter goes in the cage behind you? That is Ace, Gus, and Evil, who are my 3 rats. And they are my lovely little working from home buddies and bring me a lot of joy in my life. Does a Crown agent use 66C when requesting info from an iwi provider and vice versa? Great question. And yes, the Crown is also considered basically on an equal level with other child welfare and protection agencies for the purposes for 66C. So we will typically also use Section 66C to request from iwi providers when it involves personal information about children or young people. And the Privacy Commissioner is doing work with children and young people's privacy. And yes, we are actually involved in that working group. My colleague Perrin, who's been helping answer a few questions, is our main representative on that piece of work. We got, I think that's probably everything. We have one person, this has been answered. For a worker in a government agency, what is the difference when making a proactive disclosure between Section 15 and Section 66C? And my colleagues answered there. Section 15 allows someone to report concerns to Oranga Tamariki or a constable. That's typically referred to as reports of concern. So that's a very specific purpose for providing us with information. Whereas, as he said there, Section 66C allows us to share information more broadly. So not just in relation to reports of concerns, but it might be about, an after-school program that some young people are going on, some of that day-to-day service provision, but not necessarily anyone in direct harm's way purposes there. I think that might be all of our questions today. So I think I might just wrap us up there. But again, thank you very, very much for everybody who has come along today. And thank you very much to the people who helped me with my presentation. And a thank you to the OPC for putting on such a great Privacy Week. Kia ora, thank you, everyone.